and his concern for others, even you. He offered you forgiveness for what you did to him. Quote, "In regards to the many harms done to me, I make an offer of forgiveness to Erin. I say harms done to me advisedly. I have no power or responsibility to forgive harms done to others. However, I encourage Erin to receive my offer of forgiveness for those harms done to me with full confession and repentance. I bear her no ill will." That offer of forgiveness presents you with an opportunity. You would do well to embrace it in the manner he suggests. In commenting on the unprecedented coverage of your case, Ian Wilkinson also made this point, quote, "It's one of the distressing shortcomings of our society that so much attention is showered on those who do evil and so little on those who do good. Your lunch guests undoubtedly belong to that company of people among us who do good." The victim impact statements make it clear that each one of them, over many years, gave of themselves generously and made lasting contributions to many, many lives, and in Ian's case continues to make. All of them, inspired by their Christian faith, were deeply invested not only in their families but in their wider communities, as the statements from members of the Currumborough Baptist Church attest. A word that is used again and again in the statements to describe your crimes is, quote, "senseless." But what also surfaces in the statements is hope and gratitude for the care shown by others. Don and Gail's daughter, Anna Terrington, writes, quote, "We have to say goodbye, for now, to Mum and Dad and Heather." Don's brother, Colin, writes, quote, "As Christians, they were people of hope, and sharing that hope, my loss is not one marked by despair." Ruth Dubois expresses her great appreciation for the efforts made and compassion shown by the medical teams. Simon Patterson gives thanks, quote, "for the incredibly strong, gentle, patient and caring support from friends, family, schools, our own church congregation, the wider church, colleagues, work clients, neighbours, police, government officers and our professional counsellors. We have experienced love in a special way since the murders." I will conclude my account of key aspects of the victim impact statements with what Don and Gail's son Matthew had to say about your betrayal of trust. Quote, "Erin was embraced as part of the Patterson family. She was welcomed and treated with genuine love and respect in a way she did not appear to experience from her own family. Her actions represent a profound and devastating betrayal of the trust and love extended to her. Having regard to the aggravating circumstances of your offending and the victim impact statements, I have no hesitation in finding that your offending falls into the worst category for the offences of murder and attempted murder. As the case law makes clear, the fact that it is possible to imagine even worse instances of such offences does not refute that categorisation. The gravity of your offending warrants the imposition of the maximum penalties for your crimes. I turn then to your circumstances. The information I was provided about your personal history was minimal. Your counsel simply relied on the personal history you provided in your trial testimony. There were no psychiatric or psychological reports provided, no references from character witnesses. No doubt that approach to your plea hearing was based on your instructions, but it means the account of your personal history that I am about to give is limited. You were born in Adelaide on the 30th of September 1974, making you 48 years old at the time of your offending and 50 now. Your maiden name was Scudder. In 1977, your family relocated to Melbourne, residing in Hampton. In 2004, you and Simon Patterson met whilst you were both employed at Monash City Council. Simon told the jury that he was working there as a civil engineer and you were the RSPCA's representative on the council. By 2005, you and Simon were romantically involved. In 2006, your grandmother died, leaving you a substantial inheritance. Monies from her estate were distributed between 2007 and 2015. During those years, you would be generous with your money to Simon's siblings, providing large, no-interest loans to them and their spouses so that they could purchase their own homes. On the 2nd of June 2007, you and Simon married. You told the jury that your parents did not attend the wedding. They were holidaying in Russia. Soon after your marriage, you and Simon travelled around Australia and overseas for a few months before settling in Perth. Simon got a job working for an inner-city shire council. In 2009, when you were 34, your son was born. In April 2009, you and Simon set off with the baby to explore the top end of Australia. You reached Townsville in November 2009, at which point you parted company. You flew back to Perth. Simon drove back with the baby. You rented a cottage for you and the baby. Simon rented an on-site caravan close by. This was the first of many comparatively short-term separations. You reunited by the end of January 2010. In 2011, your father died. In that year, you also opened a second-hand bookshop in Pemberton, Western Australia. In 2013, when you were pregnant, you and Simon returned to Victoria with your son to live closer to Simon's family. In 2014, your daughter was born. In 2015, you and Simon separated permanently. In 2019, your mother died, leaving you an inheritance. In June 2022, you and your children moved into a newly constructed home at 84 Gibson Street, Leongatha, the home at which you served the fatal lunch on the 29th of July 23. You have no relevant criminal history. You maintain your innocence. In other words, there is no evidence of remorse. I turn now to the conditions of your imprisonment. As mentioned, you have been in custody since the 2nd of November 23. There were 2 affidavits tendered relating to your conditions of imprisonment. The first was sworn by a solicitor who acts for you and was based largely on your instructions. The second affidavit was sworn by Jennifer Hosking, Assistant Commissioner, Sentence Management Division at Corrections Victoria, who also testified at your plea hearing. Ms Hosking's evidence included confirmation of the following matters. You have a, quote, maximum security rating and, quote, major offender status. Because of the nature of your crimes and your notoriety, you have been assessed as being at significant risk from other prisoners. You have not been assessed as posing a risk to other prisoners. You have spent approximately 16 months of your 22 months at Dame Phyllis Frost Centre in a management unit called the Gordon Unit, and the rest of the time in a protection unit called the Murray Unit. A management unit is more restrictive than a protection unit. You have been in the Gordon Unit continuously for the last 15 months. The Gordon Unit has about 20 cells. You are not permitted to mix with the other women in the Gordon Unit. You have spent at least 22 hours in your cell every day that you have been in the Gordon Unit. There have been 16 days since November 24 where, because of lockdowns, you have been confined to your cell for the entire 24 hours per day. The maximum period that a prisoner in the Gordon Unit could have out of their cell on any given day is 4 hours, but, quote, that wouldn't happen very often. Your meals and medicine are currently delivered through a flap in your cell door. There is a small concrete yard, approximately 2 metres by 1.5 metres, which adjoins your cell, which, with permission, you may access for fresh air. If prisoners are using the larger exercise yard, which abuts your exercise yard, you may not use your small yard. During your time in the Gordon unit, you have barely had any contact with other individuals. Permission is required for you to communicate with any other prisoner, which, according to your counsel, is complicated by the fact that you are not informed of the identities of the other prisoners in the Gordon unit. You currently have approval to communicate with one other prisoner in the Gordon unit through a wire mesh when the two of you are permitted to use your respective adjoining exercise yards. That other prisoner is undergoing a lengthy sentence for terrorism offences and has attacked other prisoners. You did not ask to communicate with that person and have not communicated with her. The suggestion that you should communicate with her was made by a corrections officer. There is an intercom in your cell which, if permission is granted, you may use to communicate with one other prisoner in the unit at a time, but you have not done so. In order to attend any other part of the prison, for example the visitors' centre or the library, you are driven there escorted by two corrections officers. While, theoretically, prisoners in the Gordon unit are able to access the prison library twice per week for 20 minutes at a time, you have not been able to do so because of staff shortages and a rule that you may not access the library if another is doing so. Consequently, you have only been able to access the library a handful of times during your time in the Gordon unit. United Nations guidelines, known as the Bangkok Rules, provide that a prisoner should not be in separation for more than 15 days at a time, but you have now been in separation continuously for 15 months. There are two prisoners in the Gordon unit who have been there in excess of 3 years. And whilst the primary principle in the placement of prisoners is to manage and place them in the least restrictive environment necessary to ensure the safety and security of the individual prisoner and other prisoners, the least restrictive environment can be very restrictive. As for your future conditions of imprisonment, whilst your placement in the Gordon unit is reviewed monthly, Ms Hosking was unable to say whether you would ever be moved from the Gordon unit. I infer that given the unprecedented media coverage of your case and the books, documentaries and TV series about you, which are all in the pipeline, you are likely to remain a notorious prisoner for many years to come and as such remain at significant risk from other prisoners. I turn then to a number of relevant sentencing principles and rules. Section 5 of the Sentencing Act 1991 declares that the only purposes for which sentences may be imposed are just punishment, specific and general deterrence, rehabilitation, denunciation and protection of the community. I have had regard to all of these sentencing purposes in formulating my sentences, but rehabilitation has taken a back seat because of the gravity of your offending. Other provisions of the Sentencing Act that are of particular relevance to your case are as follows. Under Section 6A to 6F, you fall to be sentenced as a serious violent offender in respect of the 3 murders, meaning that the protection of the community is the principal purpose for which the sentences on those counts must be imposed. Under Section 6F, your status as a serious violent offender must be entered in the court records. Section 11(1) provides relevantly that if a court sentences an offender to be imprisonment for the term of her natural life, the court must, as part of the sentence, fix a period during which the offender is not eligible to be released on parole, unless it considers that the nature of the offence makes the fixing of such a period inappropriate. Section 11A(4)(a) provides that where an offender is sentenced to life imprisonment, the sentencer must fix a non-parole period of at least 30 years, unless it is not in the interests of justice to do so. Is it inappropriate to fix a non-parole period? Would fixing a non-parole period be contrary to the interests of justice? As mentioned above, this is the main dispute that I have to determine. Sentencing case law establishes that, as a general rule, harsher than normal conditions of imprisonment will warrant mitigation of penalty. There is nothing about your conduct whilst in custody which might cast doubt on the application of that general rule. As Ms Hosking indicated, you are in a management unit to protect you from other prisoners, not vice versa, nor do you have any relevant criminal history. In their written submissions, the prosecution conceded that your conditions of imprisonment are more burdensome than for a mainstream prisoner, and that they are likely to remain so for the foreseeable future. The prosecution submitted that this is a, quote, relevant consideration for sentence. In oral submissions, the prosecution conceded that this consideration was not just relevant, but, quote, important and, quote, weighty, while still pressing for life imprisonment with no possibility of parole. You have effectively been held in continuous solitary confinement for the last 15 months, and at the very least, there is a substantial chance that for your protection, you will continue to be held in solitary confinement for years to come. The Court of Appeal in Yat against the King referred without criticism to the observation that, quote, the adverse health effects of solitary confinement are well established. I note too that Ms Hosking stated at the plea hearing that, quote, being separated has negative outcomes for people. We're very aware of that. The harsh prison conditions that you have experienced already and the likely prospect of solitary confinement for the foreseeable future are important and weighty considerations which should count for something in the sentencing exercise. In my view, the only scope for making them count is by the fixing of a non-parole period. In opposing the imposition of a non-parole period, the prosecution relied on the Queen against Colston, where the offender was sentenced to life imprisonment without a non-parole period for the savage murders of 3 people. But that case makes clear that, quote, where there is a substantial factor pointing towards clemency, as I consider your present and likely future conditions of imprisonment to be, the fixing of a non-parole period may be appropriate even for an offender who has committed multiple murders. Fixing a non-parole period is not to undervalue the horrendous nature of your offending. Your total effective sentence will be life imprisonment, and the period during which you will be ineligible for parole will be a very substantial one. Please stand. For the attempted murder of Ian Wilkinson, I sentence you to 25 years imprisonment. For the murder of Heather Wilkinson, I sentence you to life imprisonment. For the murder of Gail Patterson, I sentence you to life imprisonment. For the murder of Don Patterson, I sentence you to life imprisonment. All sentences are to be served concurrently. The total effective sentence is life imprisonment, and I fix a non-parole period of 33 years. I declare that you have served 676 days by way of pre-sentence detention. Finally, and by consent, I make the disposal order sought by the prosecution. Would you please remove Ms Patterson?